So imagine someone decides they want to harm their neighbor, right? Like they are absolutely resolute about this.
Okay, setting the stage.
Yeah. So they go down to their basement, they craft this little voodoo doll out of wax, they, attach a piece of the neighbor's hair, and they just start stabbing it with a pin. And they fully, genuinely believe this is going to cause a fatal heart attack.
Right. The intent is totally there.
Exactly. The malice is there. The desire for destruction is 100% real. But if the police kick down the door and find them doing this, I mean, can they be arrested for attempted murder?
I mean, it's the perfect paradox to start with, honestly, because, well, from a purely moral standpoint, yeah, that person's mind is totally guilty. They've committed a pretty severe wrong in their own head.
Right.
But from a legal standpoint, a voodoo doll is physically incapable of causing a heart attack. So the law simply cannot punish a scientifically impossible act. Like, no matter how malicious that internal monologue of the actor might be.
And that gap, that massive, really fascinating gap between, what makes someone a bad person and what makes someone a punishable criminal, that is exactly what we are exploring today. So welcome to this custom-tailored deep dive. We are taking you, the listener, straight into the lecture halls of Osmania University today.
Yeah, specifically, we're dissecting Unit I of their Law of Crimes curriculum.
Exactly. And our mission today is basically to equip you with the rigorous analytical mindset of a university law student. We are going to look at the exact anatomy of human behavior, but entirely through the lens of the law.
And, we are doing this at a uniquely pivotal moment in history, too. We're drawing directly from these really comprehensive academic notes that analyze the transition from the old Indian Penal Code.
The IPC of 1860, right?
Yeah, the IPC. And the shift from that to the newly minted Bharatiya Sanhita 2023, which we'll just refer to as the BNS for short.
Yeah, it makes it easier.
For sure. But we're going to break down how, a mere thought transforms into a punishable offense, how the burden of proof shifts around, and really how the very definition of a crime has fundamentally evolved in India.
Okay, so let's unpack this.
Yeah.
Because to really understand what a crime actually is today, we have to look at the ghost that the BNS is replacing, right, the IPC, sure. Enacted in 1860.
1860,
right.
Yeah.
I mean, mid-19th century. Just to put that in perspective for you, the telegraph was cutting-edge technology back then. And the British designed this code with a very specific structural DNA. It wasn't built to foster a free society. I mean, it was built to control the quote-unquote subjects of colonial rule.
Yeah, and that distinction between a subject and a citizen that dictates the entire architecture of a legal code, the British formulated the IPC to protect foreign interests, basically.
Right.
If you look at the historical sequence of offenses in that 1860 code, it heavily prioritized offenses against the state. The protection of the individual human being, your life, your liberty, your body, that was structurally secondary. Wow.
Yeah, the primary objective was really just to curtail any speech or action that might challenge foreign rule.
But wait, I mean, obviously the IPC also made things like murder and theft illegal, right? It governed everyday life in India for over a century. So how did that, control the subject's DNA actually manifest in a way that required a total overhaul in 2023? Why not just, amend the IPC?
Well, because a foundational philosophy kind of bleeds into the actual mechanics of the law.
Okay, how so?
When a code is designed to prioritize state power, it tends to rely on really broad, ambiguous language. And that allows the state maximum flexibility to prosecute whoever they want while offering the individual minimum protection.
I see.
Plus, as the Osmania University notes point out, the IPC completely failed to address the contemporary needs of a modern independent republic. I mean, offenses against women and children were scattered around chaotically. Minor girls and minor boys were treated totally differently, these archaic legal contexts.
Right. It just lacked cohesive laws protecting the actual sovereignty of India in a modern democratic framework.
So we aren't just talking about installing a software update here. This is entirely tearing down the colonial prison and building a modern courthouse from the ground up.
Exactly.
The BNS 2023 is described in our source material as victim-centric and rights-based, really aligning with modern constitutional values. So let's look at the actual mechanics of that shift. Where do we see this rights-based philosophy actually changing the language of the law?
Well, the most profound changes happen in the definitions because, in a courtroom, a definition is quite literally the line between a conviction and an acquittal.
Right.
So let's examine sexual offenses. Under the old IPC, the legal phrasing regarding a lack of consent often relied on the term against her will.
Oh, wow. I can immediately see the defense attorney's strategy there. I mean, will is this incredibly nebulous philosophical concept. If a victim is paralyzed by terror and just remains silent, a defense attorney will argue, well, she didn't physically fight back, so her will wasn't overcome. Like the ambiguity entirely protects the perpetrator.
Precisely. That ambiguity creates a loophole large enough to drive a truck through. But the BNS eliminates that ambiguity. Under Section 64 of the new code, that vague phrase, against her will, is completely gone.
Oh, that's a big deal.
It is. It's replaced with a demand for affirmative clarity. Consent is now legally defined as, and I'm quoting here, consent given in a conscious, voluntary, and informed state.
Okay, let me challenge the practical application of that for a second. Adding the word informed seems like a massive legal hurdle. Doesn't that imply that if a perpetrator uses deception like maybe lying about their identity or concealing some crucial fact, the consent is legally void because the victim wasn't fully informed?
That is exactly the point. Yeah, it elevates the standard of human dignity. It dictates that you cannot manipulate someone into submission and then just call it consent. The state of mind has to be conscious and voluntary, completely free from fraud or coercion, and this level of precision really removes the shadows where perpetrators historically hid in courts.
That's fascinating. But the structural cleanup goes way beyond just definitions, though. I mean, the BNS actively amputates laws that simply don't fit a modern constitutional republic anymore. Like, the sources note the complete removal of sedition, which was formerly Section 124A of the IPC, and the removal of adultery, which was Section 497.
Right. And to view this impartially, just strictly through the lens of our academic sources here, the removal of these specific provisions is basically just a reflection of constitutional consistency.
Right, because we aren't taking any political sides here, just reporting what the notes say.
Exactly. The modern Indian Constitution guarantees fundamental rights, like the right to free speech and the right to privacy and bodily autonomy. So over time, judicial scrutiny recognized that these specific archaic colonial-era laws were just fundamentally incompatible with those modern guaranteed rights.
So the BNS is essentially the legislative body just catching up to the constitutional reality.
Yeah, pretty much.
So it's out with the Victorian moral policing and out with the imperial protections.
Right.
But what about what's being added? Because obviously a code written in 1860 is completely blind to the reality of 2023.
Oh, for sure. The IPC was a constant exercise in forcing square pegs into round holes. I mean, you had prosecutors trying to use 19th century definitions of trespass or harassment to prosecute modern digital crimes.
Which doesn't work at all.
Not at all. So the BNS introduces dedicated provisions for the modern era. We are looking at explicit criminalization of things like cyberbullying, the misuse of technology in sexual crimes, voyeurism under Section 77, and stalking under Section 78.
And there are linguistic tweaks, too, right?
Yeah.
Tweaks that reflect a shifting societal understanding of humanity itself.
Yeah.
Like Section 2, subsection 10 of the BNS defines gender.
Yeah.
And it doesn't just stick to the binary male-female paradigm of 1860.
No, it explicitly includes transgender.
Which is huge.
It's a vital inclusion for any framework that claims to be rights-based. I mean, the law must visibly recognize the existence of the actual people it governs. Furthermore, the BNS engages in some heavy legislative housekeeping.
Yeah.
Yeah, like Section 2, subsection 5 streamlines these clunky Victorian phrases, changing court of justice to simply court. And they purged all these outdated illustrations, like there was a reference to a panchayat acting under a Madras code from 1816.
Gupsy, from 1860?
Yeah, it was still in there.
That's wild. But here is a piece of legislative housekeeping that initially confused me when I was reading the notes. They highlight that the BNS completely removed the definition of electronic record, which used to be Section 29A in the IPC. If this is supposed to be a modernization for the digital age, why delete the definition of an electronic record? That makes no sense.
Well, it seems counterintuitive until you zoom out and look at the broader legal ecosystem in India. They already have the Information Technology Act of 2000.
Oh, right.
And that act provides an incredibly comprehensive, specialized, and constantly updated framework for digital concepts. So by removing the definition from the BNS, the criminal code avoids creating a conflicting or watered-down definition.
So it just defers to the IT Act.
Exactly. It defers to the specialized statute. It's a really sophisticated way of keeping the criminal code streamlined.
Okay, so we have established the new rulebook. The BNS is modernized, it's cleaned up, and it centers the dignity of the individual. But that brings us to the foundational philosophical question of this entire curriculum.
Which is?
Now that we have the definitions, what actually warrants the law's attention? Like, let's say I borrow your expensive lawnmower, I leave it out in the rain, and the engine rusts out. I have committed a wrongful act. I wronged you.
You definitely did.
But the police are not going to kick my door down and arrest me for a rusty lawnmower. So how does the law separate a personal grievance from a punishable crime?
This is where we have to define the boundary between a crime and a tort.
Okay.
In jurisprudence, a crime is defined as a public wrong. It is an act or omission prohibited by law and punishable by the state. And the critical conceptual leap here is understanding the scope of the injury.
What do you mean by scope?
Well, even if a crime harms an individual directly, like if someone breaks into your house and steals your television, the law views that not just as an injury to you, but as an injury to society at large.
Oh, I get it, because it fractures the social contract. Like if the state just allows people to kick down doors and steal televisions without consequence, the entire fabric of safety and commerce and order just unravels for everyone.
Exactly the mechanism at play. The state steps in because the act threatens the collective peace. Now, contrast that with the tort. A tort is a private wrong. It's a civil wrong committed by one individual against another individual.
Like the lawnmower.
Right. The state's fundamental existence is not threatened by your rusted lawnmower. Therefore, the state does not step in as the prosecutor. The injured party, which would be me in this case, must seek a remedy in a civil court against the person who wronged me.
Okay, the Osmanian notes actually outline 6 key differences between these two tracks of justice, and walking through how they function really illuminates the architecture of the legal system.
Yeah, let's do a hypothetical.
Okay, let's say I am driving my car, I'm texting on my phone, I run a red light, and I smash right into your living room window. Let's look at the nature and objective of how the law handles this mess.
Well, in that scenario, 2 parallel systems of justice are actually triggered simultaneously. Let's look at the tort track first.
Okay.
The nature of the tort is private. The objective of the court track is compensation. So the civil court looks backward at the event and asks, how do we make the victim whole again? And the remedy there is monetary damages. I, as the injured party, initiate the proceedings. I am the plaintiff, you are the defendant.
So you sue me?
Yes. I sue you for the cost of my window, my ruined sofa, and my emotional distress.
But the state doesn't just let me write you a check and walk away.
Yeah.
Right? Because running a red light while texting is a massive public danger. So, parallel to your lawsuit, the crime track activates.
Exactly.
The nature is public. The objective isn't compensation, it's punishment and deterrence. The court looks forward and asks, how do we penalize this behavior so no one else does it?
Yeah.
The proceedings are initiated by the state. It becomes, the state versus the host.
Right. And the remedy, as outlined in sections 4 through 13 of the BNS, isn't just writing a check to me. It's paying fines to the government or potentially facing actual imprisonment.
Which brings us to the most vital difference, and honestly, the one that defines the dramatic tension of every legal thriller you've ever watched. The standard of proof.
Oh, yeah.
Because the consequences are so vastly different. The referee in each court demands a completely different level of certainty.
Right, because if we connect this to the bigger picture, taking away someone's liberty is vastly more severe than taking away their money.
It's fascinating. In your civil lawsuit against me for the window, the referee, the judge, uses a standard called the balance of probabilities. It's essentially 51% certainty. You just have to prove that it is more likely than not that my negligence caused the damage. If the scales tip even slightly in your favor, I have to pay up.
But the criminal court, where the state is trying to throw you in jail, that demands a drastically higher bar.
Beyond a reasonable doubt.
Exactly. The criminal standard is beyond a reasonable doubt. The state must prove its case to an overwhelming degree of certainty. Why? Because the philosophical weight of taking away a citizen's liberty, literally locking a human being in a cage, stripping them of their freedom of movement, their family, their livelihood, is the most severe action a government can take.
Right.
So society has collectively decided that it is better for 10 guilty people to go free than for one innocent person to be unjustly stripped of their liberty.
It's an incredible asymmetrical burden placed entirely on the government. And that burden leads us directly into what exactly the government have to prove. I mean, if they need 99% certainty, what are the actual building blocks of guilt?
This is where we turn to the foundational Latin maxim of criminal jurisprudence. Actus non facit reum nisi mens citrea.
Let me guess. An act does not make one guilty unless...
Unless there is a guilty mind. Exactly. For a person to be held criminally liable, 2 distinct components must converge at the exact same moment. The external physical reality, which is the actus reus, and the internal psychological reality, which is the mens rea.
Okay, let's dissect the physical side first. The Actus Reus, the guilty act. It's not just doing a bad thing, right? The text is very specific about the requirements. The conduct must be voluntary, and there must be a direct, unbroken chain of causation between the act and the harm.
Yeah, voluntariness is key here. Like if someone violently pushes you and you stumble into a third person, knocking them off a balcony, you have physically committed the act that led to their death.
But I didn't do it voluntarily.
Exactly. You lacked voluntariness. Your body was basically merely a projectile used by someone else. So there is no actus reus on your part.
Okay, that makes sense. The notes detail 3 specific forms that actus reus can actually take. The first is commission, which is pretty straightforward. It's actively doing something prohibited, firing a weapon, taking a wallet, forging a signature.
Right. But the second form is far more complex. Omission.
Failing to act.
Yes, failing to act. Now, the law does not demand that you be a hero.
What do you mean?
Well, if you are walking by a shallow pond and you see a stranger drowning and you simply stand there and watch, you might be a moral monster, but you have not actually committed a crime. Omission only becomes actus reus when you have a strict legal duty to act.
Wow. Okay, give me a scenario where that legal duty fundamentally alters the criminality of doing nothing.
The Osmanian notes use the really stark example of a parent and a dependent child. A parent has a legally binding duty of care to provide sustenance to their child. If a parent intentionally fails to feed that child and the child perishes, the parent's lack of action is the actus reus.
Because of the legal duty.
Exactly. Their omission is legally identical to a physical attack. Another example would be a hired lifeguard watching someone drown in their designated zone. Their employment creates the legal duty to intervene.
That makes the boundary very clear. Now, the third form of actus reus is really intriguing to me. State of affairs. This isn't doing an action or failing to do an action. It's simply being in a prohibited condition.
Yeah, the classic example is being found intoxicated in a public space to the point of causing a disturbance. The prosecution doesn't need to prove you took a specific swing at someone or yelled a specific word. The mere state of your existence in that condition, in that location, constitutes the physical act.
So the state proves you physically did it, omitted it, or existed in it. But remember the Latin maxim. The physical act is only half the equation. I mean, a sleepwalker can commit a physical act. To secure a conviction, the state must cross the hardest hurdle in all of jurisprudence, proving the mens rea.
The guilty mind.
Right, the internal component. Now, I always look at mens rea kind of like a magic trick.
How so?
Well, if I go to a magic show, I can't actually see the magician's thoughts. I can't read their mind. I can only infer what their intent is based on the props they've set up, the trapdoors they built, the way they misdirect my attention.
Right, right.
In a courtroom, a jury can't crack open a defendant's skull and look at their thoughts. So how does the law categorize and prove something entirely invisible?
Your analogy is exactly how the courts operate, actually. They infer the internal mental state from the external surrounding circumstances, and the law categorizes this invisible intent into a hierarchy of culpability. The text breaks mens rea down into 4 distinct levels of severity.
Okay, the apex, the absolute highest level of culpability, is intention.
Yes. Intention is the deliberate, conscious desire to bring about a specific prohibited harm. You aim a firearm at a specific individual's chest and pull the trigger because your explicit goal is to end their life. The foresight of the consequence and the desire for it are perfectly aligned.
Let me test the next level down then, which is knowledge. How is knowledge different from intention? I mean, if I know something is going to happen, isn't that basically the same as intending it?
Not legally, no. Let's use an extreme hypothetical here. Suppose a person decides they want to collect an insurance payout on a commercial airplane they own.
Okay.
They place an explosive device in the cargo hold, set to detonate mid-flight. Their intention is solely to destroy the property to get the money. They might not actively desire the deaths of the passengers. Maybe they even feel terrible about it.
But they know it's going to happen.
Exactly. They possess the absolute knowledge that the destruction of the plane will unequivocally result in the deaths of everyone on board. The law treats that knowledge acting with the certainty of the fatal consequences, even if the death wasn't the primary emotional goal, as a severely culpable state of mind.
Ah, that clarifies it perfectly.
Yeah.
You might not want the secondary effect, but you proceed knowing it's an inevitable collateral damage.
Right.
Okay, the third level is recklessness.
Recklessness is the conscious disregard of a known, substantial, and unjustifiable risk. You aren't certain the harm will happen, but you know there's a massive risk, and you just decide to roll the dice anyway.
Like what?
Like driving 100 miles per hour through a crowded school zone while blindfolded. You don't intend to hit a child, and you don't necessarily know you will hit a child, but the risk is astronomical, and you chose to ignore it.
Which brings us to the fourth level, negligence. And I want to dig deep into this because the source material draws a very sharp, very important line between civil negligence and criminal negligence.
It does.
Let's go back to my car crash hypothetical. If I am in a parking lot, checking my mirrors, but I just misjudged the distance and crack your bumper, that's civil negligence. I failed to exercise the care a reasonable person would. I pay you damages. It's a tort.
Right.
But how does that escalate into criminal negligence?
Well, criminal negligence requires a massive quantum leap in carelessness. It isn't just a lapse in judgment or a momentary distraction. It requires a showing of gross, flagrant misconduct that demonstrates a callous disregard for human safety.
Oh, wow.
Yeah, the examples highlighted in the text are severe, like rash driving on a highway resulting in fatalities, or egregious medical malpractice where a surgeon operates while heavily intoxicated.
So the state is looking for a level of negligence that actively shocks the conscience of society. That's what triggers the BNS punishments instead of just an insurance claim.
Exactly.
Now, having said that the state must prove mens rea, the notes explicitly carve out this massive exception where the mind doesn't matter at all.
Ah, yes. The doctrine of strict liability.
Under strict liability, the state can basically just throw the Latin maxim out the window. Like, if I run a red light, the police officer pulling me over does not care about my mens rea at all. I can explain that I didn't intend to do it, I didn't know I was doing it, I wasn't being reckless, and I was trying my best not to be negligent.
And the officer will just hand you the ticket.
Exactly. Why does the legal system suddenly abandon its foundational requirement for a guilty mind?
It abandons it strictly for public welfare and regulatory offenses. Think traffic violations, environmental pollution regulations, food adulteration laws. In these specific arenas, the potential harm to society is so widespread, and the difficulty of proving subjective intent is so incredibly high, that the legislature decides the public interest just overrides the requirement for mens rea.
So just doing the act is enough.
Right. Doing the physical act selling tainted meat, running the red light, is in itself the totality of the crime. The law imposes an absolute duty to comply.
Okay, so we have assembled the building blocks. We have the physical actus reus, and we have the internal mens rea. But a crime is rarely a spontaneous microscopic flash in time, right? It is a narrative arc. It is a beginning, a middle, and a climax.
It's a process.
Exactly. So we need to understand the timeline of a crime. When exactly does an action cross the invisible legal line and trigger the BNS?
Criminal jurisprudence divides the lifespan of an offense into 4 distinct sequential stages, and tracing this timeline is essential to understanding how the state balances early intervention with individual freedom.
Okay, stage 1 is intention, the inception of the idea, the formation of the mens rea, and the text establishes an absolute, unbreakable rule here. Mere intention is never punishable.
We circle back to your voodoo doll example, or simply someone lying in bed fantasizing about robbing a bank. The law operates in the physical realm. It cannot police the imagination. Until that internal thought manifests into an external action, the state is entirely powerless. Thought crimes do not exist.
But eventually, the person gets out of bed, which leads to stage 2, preparation. This involves taking tangible steps, gathering resources, scoping a location, arranging the means to commit the offense. Now, generally, the Osmania notes state that preparation is also not punishable.
That's right.
Let me play devil's advocate here. If the state knows I'm actively buying blueprints to a bank and purchasing an acetylene torch, why wouldn't they arrest me to protect society before I can strike?
Because human nature is volatile, and the law recognizes the capacity for redemption right up until the final moment. A person might buy the torch, study the blueprints, drive to the bank, and then suffer a massive crisis of conscience.
They chicken out.
Or they just realize the sheer weight of what they're about to do and simply turn around and go home. The law deliberately preserves what we call a locus poenitentiae, an opportunity to repent. If preparation were punishable, there would be no incentive to abandon the plan once you bought the tools. You'd already be guilty.
That makes perfect philosophical sense. You want to leave the exit door open for the criminal as long as possible. But the law is also pragmatic, and there are terrifying exceptions. The notes provide specific instances under the BNS where the mere act of preparation is a fully punishable offense.
Yeah, the exceptions occur when the intended crime represents an existential threat to the state or a massive, overwhelming threat to public safety, where waiting for an attempt is simply too dangerous. The first example is preparing to wage war against the government of India. The state will absolutely not wait for the artillery to fire.
Right. And the second example is preparation to commit dacoity.
Yes.
Now, dacoity is a very specific term in Indian criminal law, right? It isn't just a standard robbery.
No, it is legally defined as robbery committed by a gang of 5 or more persons. And the reason preparation for dacoity is criminalized is deeply rooted in psychology. When an individual plans a robbery, they might hesitate. But when 5 or more people conspire, coordinate, and prepare together, a dangerous group dynamic takes over. The collective momentum removes individual hesitation. The threat to a community from a heavily armed, coordinated gang of 5 is so severe that the state criminalizes the mere assembly and preparation of the tools.
Wow. Okay. So barring those extreme exceptions, stage 2 is safe. But then we cross the threshold into stage 3, attempt. This is the moment the law bears its teeth. Attempt is defined as a direct movement toward the commission of the crime after the preparation is complete.
Exactly. Under Section 62 of the BNS, an attempt is a fully punishable offense, even if it fails. The law typically punishes a failed attempt with up to half the maximum term of imprisonment prescribed for the completed offense.
The text uses this classic pickpocket illustration. A person intends to steal a wallet. That's stage 1.
Yeah.
They stand near a crowded train door to find a target. That's stage 2, preparation. Then they reach their hand directly into a passenger's pocket. That is the direct movement. But the pocket is empty. The wallet was left at home. They physically failed to commit the theft.
Yet, they're fully liable for the attempt to commit theft. Why? Because they possessed the requisite mens rea, and they executed the Actus Reus to the absolute furthest extent possible.
Because they tried.
Exactly. The only reason the crime wasn't completed was an intervening external factor, an empty pocket, not a voluntary change of heart. Their danger to society was fully manifested.
The notes highlight an even more severe scenario, too. Attempt to murder, which is governed by Section 109 of the BNS. To secure a conviction here, the prosecution must prove 3 distinct elements. First, the explicit intention to kill or knowledge that the act is likely to cause death. Second, a direct movement toward commission. And third, the act must go definitively beyond mere preparation.
And if those criteria are met, the BNS prescribes some incredibly stringent punishments. An attempt to murder can carry a sentence of up to 10 years imprisonment. Crucially, if the victim is actually hurt during that failed attempt, the punishment can escalate to life imprisonment.
And finally, we have stage 4, commission. The tragic climax. The crime is successfully completed, the harm is done, and the full weight of the punishments outlined in sections 4 through 13 of the BNS comes crashing down.
Yes.
Let me pause us here, though, because while laying out the 4 stages sounds very neat and clinical, the real world is incredibly messy.
Oh, always.
Let me present a hypothetical to truly test the boundary between stage 2, preparation, and stage 3, attempt. The Rubicon moment, as you called it.
I welcome the challenge. Let's see where the line is.
Okay. A man decides to rob a jewelry store. He buys a ski mask and a crowbar. Stage 2, preparation.
Legal.
Agreed. He drives to the jewelry store at 2 a.m. and parks his car across the street. He's sitting in his car with a crowbar. Still preparation.
Yes. He can still start the engine and drive away. The locus poenitatere remains open.
Okay. He gets out of the car, walks across the street, stands directly in front of the glass door, and pulls the ski mask over his face. He hasn't raised the crowbar yet. Attempt or preparation.
Oh, man. That is exactly where you enter the crucible of legal debate. Defense attorneys and prosecutors will battle fiercely over that exact inch of pavement. The courts apply a test analyzing proximity and unequivocal intent. Has the actor taken a step that cannot reasonably be interpreted as anything other than the execution of the crime?
I mean, a defense attorney might argue he was just testing the mask to see if it was warm, and he was about to walk away.
Right, and the prosecutor will argue that standing in front of a locked store at 2 a.m. in a mask is a direct movement toward commission. However, jurisprudence generally dictates that until he raises the crowbar or touches the door handle, he is still technically in the realm of preparation, however precarious that is.
Really?
Yeah. The moment he grips the handle or swings the tool, he crosses the threshold. The actus reus of attempt is solidified.
It is a razor-thin wire the justice system has to walk. Punish too early and you are tyrannical, arresting citizens for ambiguous actions. Punished too late, and the glass is broken, the victim is harmed, and the state has failed its duty to protect.
It's a delicate balance.
So we've explored the history. We've mapped out the psychological and physical architecture of a crime. We've tracked its evolution through the 4 stages. The final massive piece of this puzzle is geography. We have this new, powerful rulebook, the BNS. But where exactly does it apply? What are the actual borders of India's legal authority?
You are asking about jurisdiction. It is the preliminary question before any trial can even begin. Does this specific court possess the legal authority to pass judgment on this specific individual for this specific act?
Right.
The BNS, in sections 1, 2, and 3, establishes 2 massive pillars of authority: territorial and extraterritorial jurisdiction.
Let's start with territorial jurisdiction, which is anchored in Section 2 of the BNS. This seems relatively intuitive to me. It establishes the authority of Indian courts over offenses committed within the physical, geographical boundaries of the Republic of India.
And geographical boundaries is a very comprehensive term. It encompasses the landmass, the internal waters, the territorial sea extending into the ocean, and the airspace above it all. The principle is simple. If the Actus Reus occurs on Indian soil, Indian law applies.
And crucially, it applies universally to anyone standing on that soil. It does not matter if the offender is a lifelong citizen of Mumbai, a tourist from Canada on a 2-week visa, or a foreign national conducting business. If you are within the borders, you are subject to the BNS.
Exactly. Territorial sovereignty demands that the state maintain order within its borders, regardless of the passport held by the offender. Ignorance of Indian law by a foreign tourist is absolutely not an excuse.
But then the text introduces extraterritorial jurisdiction, outlined in Section 1 and specifically operationalized in Section 3, the BNS. And this concept is staggering. This is the power of the law to shatter physical borders entirely.
It is a profound assertion of state sovereignty. Indian courts have the authority to try and punish offenses committed entirely outside the geographical boundaries of the country, provided the offender is a citizen of India.
It's like an invisible, unbreakable tether attached to your citizenship.
Yeah.
Let's explore the specific illustration provided in the Osmania notes to see how this mechanically functions. They introduce a hypothetical individual, Mr. A.
Mr. A is an Indian citizen. Let us place him in the United Kingdom for a business trip, as suggested by the contemporary updates to the text.
Okay.
While in London, entirely outside the physical jurisdiction of India, Mr. A gets into a severe altercation and commits a murder.
Realizing the gravity of what he has done and terrified of the UK legal system, Mr. A immediately flees to Heathrow, boards a plane, and flies back to his home in Hyderabad. The UK authorities piece together the evidence, identify Mr. A, and send a diplomatic notice to India. Now, the crime happened in London. The victim might be British. The weapon is in the UK. Can a judge sitting in a courtroom in Hyderabad try Mr. A for a murder that occurred 4,500 miles away?
The verdict under Section 3 of the BNS is an unequivocal, resounding yes.
Wow.
The section explicitly states that any citizen of India shall be liable to punishment for an offense committed outside India in the exact same manner as if the offense had been committed within India.
The language in the notes is striking. He can be tried and convicted of murder in any place in India in which he may be found. The moment he steps off that plane in Hyderabad, the BNS wraps around him.
And if you look closely at the linguistic evolution from the old IPC to the BNS, there is a subtle but vital reinforcement of sovereignty here. The old colonial law phrased this extraterritorial reach as being judged by any Indian law.
Okay.
The newly drafted BNS refines this, stating he will be judged by any law for the time being in force in India.
Ah, that phrasing feels much more dynamic. It ensures that the citizen is held to the absolute most current standard of the Republic's values, not just an arbitrary list of rules.
Precisely.
But I have to push back on the philosophy of this. Why does India, or any sovereign nation for that matter, want this burden? If Mr. A commits a crime in London, why not just say, that's London's problem, let them deal with it? Why does the BNS aggressively chase its citizens across oceans?
Well, for 2 vital reasons. The first is the prevention of safe havens. The international system simply cannot function if individuals can just commit atrocities in one jurisdiction and then use their passport as a shield to escape justice by fleeing home. The law must ensure that borders are not exploited by fugitives.
You can't just play a geographical game of tag to escape a murder charge.
Exactly. And the second reason goes to the core of international responsibility. When a sovereign nation issues a passport, it is essentially vouching for that citizen on the global stage.
That makes sense.
If that citizen commits a grave offense abroad, the home nation has a moral and legal obligation to ensure accountability. Holding an Indian passport grants you the protection of the state, but it inextricably binds you to the obligations of the BNS, no matter where you travel on the globe.
It is a remarkable framework.
Yeah.
I mean, we have covered an incredible sweeping expanse of jurisprudence today. We started in 1860, examining the colonial DNA of the IPC, a code designed to subjugate and control.
Right.
We watched the legal architecture physically transform into the BNS of 2023, analyzing how it redefines consent, acknowledges digital age threats, and attempts to center the dignity of the modern citizen.
We dissected the crucial barrier between a private tort and a public crime, exploring why the state demands an overwhelming 99% certainty proof beyond a reasonable doubt before it will wield its power to strip away human liberty.
We pulled out the microscope and looked at the exact building blocks of guilt, the physical necessity of the Actus Reus, and the invisible inferred intent of the mens rea.
And we tracked the timeline of human action.
Yeah, from the unpunishable realm of dark thoughts, through preparation, across the treacherous legal Rubicon into attempt, and finally, commission.
And we concluded by mapping the borders of the law itself, seeing how Section 3 of the BNS acts as an invisible tether, allowing justice to reach across continents to hold a citizen accountable.
So, after this hour in the Osmania University Lecture Hall, why does this matter to you? Because understanding this complex, invisible machinery fundamentally changes how you interface with society. The next time you watch a high-profile trial on the news or read about a controversial arrest, you are no longer just consuming the sensationalism.
You know, to look for the mens rea.
Exactly. Was this a tragic accident of civil negligence, or was it reckless criminal misconduct? To analyze the stages, did the police intervene during mere preparation, or was there a direct movement to attempt? You are equipped to see the raw code that dictates the consequences of human behavior.
But if we synthesize everything we've explored today, the modernization of definitions, the requirement of physical acts, and the extra-territorial reach of the law, it leads us to a profound, unresolved question about the immediate future.
The law is always chasing technology. What is the next frontier?
Well, we established that the BNS deliberately removed the definition of electronic records because digital realities are so complex they require specialized IT laws. We also established that Section 3 allows the criminal code to chase an Indian citizen across physical borders all the way to a street corner in London.
The tether works perfectly in the physical world.
But what happens when human interaction fully migrates into the metaverse? If a crime legally requires a physical actus reus and a mens rea, but the act happens through a digital avatar in a completely borderless, decentralized virtual reality, where exactly is the crime committed?
Oh, that is a mind-bending legal nightmare.
Think about it. If a citizen sitting in a cafe in Hyderabad uses virtual reality to commit a digital assault against an avatar controlled by a user in London, and the interaction is hosted on a decentralized server node in Singapore, whose territorial jurisdiction applies.
I don't even know where to start with that.
Does the actus reus happen where the physical body is sitting, where the server is humming, or in the digital space where the avatar was injured? Does Section 3 of the BNS extend into a reality that has no physical geography?
We started this deep dive talking about how the medical X-ray machine is broken when you look at the human mind, and how the law has to navigate those diagnostic muddy waters. It seems like the digital age is about to vaporize the water entirely. The BNS might be a brilliant, modernized operating system for the physical realities of 2023, but the next update might require a completely new understanding of what an act and a place even are. A thought to mull over until next time.